Didn't mean to have the audio coming through on that. Greetings, animals. Going to be doing another reading stream today. Might even finish the book. I don't know. We're getting pretty close. In 1 second, just to verify that all the streams are up and running, especially over on Odysee. We will get started. All right. Looking forward to this. Looking forward to the next book, too. All right, we are at the chapter Smart Contracts. Let's get started. What is a contract? Why are they binding? How are they enforced? We sign contracts all the time and pay lawyers a ton of money in the process. But how many of us have actually stopped to think about the principles that back contracts? Should all promises be enforceable or only those tied to consideration? Why or why not? The answers to these questions reveal subtle principles that are critical to sustaining a true democracy. Murray Rothbard and Williamson Evers developed the title transfer theory of contract, which I believe contains critical concepts for a true democracy. Rothbard's derivation of property rights is based on the theory of homesteading or first use. Well, homesteading in terms of Locke, not in terms of first use, I believe. I believe that came after, but all good. And is vastly different from my derivation of property rights as a peace treaty. That said, his theory of contracting relative to defined property rights is still relevant. While other philosophies claim rights as fundamental axioms derived from axiomatic moral stances, such as the non-aggression principle. Hold on. I'm going to read that last paragraph one more time. Murray Rothbard and Williamson Evers developed the title transfer theory of contract, which I believe contains critical concepts for a true democracy. Rothbard's derivation of property rights is based on the theory of homesteading or first use and is vastly different from my derivation of property rights as a peace treaty. I think this could be projecting my own arguments onto Rothbard, so I could be wrong in this. But I think Rothbard's conception of homesteading was still based upon... Maybe he never mentioned it. Maybe I'm just assuming. What was the... yeah. I'm going to have to go look that up. Did Rothbard ever even make a claim as to what gave homesteading the power, quote-unquote power, quote-unquote authority to bestow ownership? I'm going to have to look that up now. If anybody knows, tell me in the comments. Okay. That said, his theory of contracting relative to defined property rights is still relevant. While other philosophies claim rights as fundamental axioms derived from axiomatic moral stances, such as the non-aggression principle, I claim that there is no support in nature for their principles. At best, their philosophies amount to a proposed peace treaty. While I reject their axioms as such, I feel that there are ample lessons to be learned from Rothbard's work about how to design a logically consistent and enforceable peace treaty, i.e. true democracy. Backing up, while other philosophies claim rights as fundamental axioms derived from axiomatic moral stances, such as the non-aggression principle, I mean, I wouldn't... some people would certainly describe it that way. I would not. He says then, I claim that there is no support in nature for the principles. Yes, I concur with that. At best, their philosophies amount to a proposed peace treaty. Yeah. To elevate ourselves out of nature, we have to reciprocate rights with people that are willing to reciprocate back with us. While I reject their axioms as such, I feel that there are ample lessons to be learned from Rothbard's work about how to design a logically consistent and enforceable peace treaty, i.e. true democracy. One of the most important aspects of a peace treaty is to define who owns what and how ownership changes and how disputes are resolved. Any confusion over ownership creates conflict, and conflict is supposed to be resolved by a peace treaty. Therefore, it follows that the peace treaty should define the process by which individuals may contract with respect to their property such that it minimizes ambiguity. This in turn brings up the question of what constitutes a valid contract and how are they to be enforced. Before expanding on what that means, let's review how contracts typically operate today. Contracts are generally combinations of promises to do or to give something. If you are buying a coffee, you verbally contract to give title to cash conditioned on receiving title to a cup of coffee. This contract need not be written down to capture the intent of the parties. This is an example of a to-give contract. A to-give contract could be easily represented on a blockchain as a smart contract, assuming you created digital titles linked to a physical things. To physical things, I think I meant. A to-do contract could be something like an employment contract. Here you promise to work 40 hours in a horseshoe nail factory next week, and someone else promises to pay you cash. In the event you choose not to work, it could be considered a breach of contract. In the simple case, you simply don't get paid. However, in the worst case, the kingdom could be lost. Recall the story from the chapter on designing for independence. For want of a nail, the shoe was lost. For want of a shoe, the horse was lost. For want of a horse, the rider was lost. For want of a rider, the message was lost. For want of a message, the battle was lost. For want of a battle, the kingdom was lost. And all for the want of a horseshoe nail. Failure to perform on a contractual promise can cause grave damages to other parties relying on that promise. When these issues are taken to court under traditional contract theory, the judge will rarely compel you to perform the service. Instead, the judge will usually order you to pay damages to the other party. There is a problem with this, though. What are the damages? How is anyone supposed to know the extent to which other parties rely upon their promises? Well, I think this might be a problem with the current sort of United States government implementation of it. I think the answer to that is to just put it in the contract. If you fail to show up to work to make horseshoe nails, you agree to transfer me X number of dollars, either at the time of or as soon as you at next you come into possession of X number of dollars, the title, the proper ownership of that X number of dollars gets automatically transferred to me. If it's explicitly spelled out in the contract, then it's not as much of a problem. Would you take a job that promised to pay you $10,000 to work 40 hours next week? But if you change your mind, you own them? Oh, probably a little typo. Let me translate this. Would you take a job that promised to pay you $10,000 to work 40 hours next week, but if you change your mind, you owe them $10 million in damages? Suppose you get sick or are in a car accident. Let's assume for a moment that the other party really would experience a $10 million loss without your performance, and that this isn't just a huge and unreasonable penalty. If you knew they were relying on you to the tune of $10 million in damages, then chances are you would demand higher compensation in the first place, and you would take out insurance to cover any events beyond your control that could make you liable for $10 million. Yeah. If it's not this is me talking, if it's not in the contract, then nothing should happen. No judge in a black dress should be able to force resource transfer if it wasn't in the contract. If you knew they were relying on you to the tune of $10 million in damages, then that's why $10 million was written down in the contract. And the other consideration that wasn't accounted for there is not only would the person accepting that contract get insurance to cover events beyond their control, but the other side would have to either have some kind of bond in the amount of $10 million to make sure that they had money set aside to pay. They would You need to have an insurance policy that agreed to pay out in the event that they didn't have $10 million to pay or something like that. Like those would be requirements that you would want when dealing with quantities of money that much. Or maybe you wouldn't. Like, so for much smaller amounts, maybe the cost of the run around and getting that insurance and working out all those details is greater than the cost of eating the losses or whatever. So you wouldn't. You would just eat the losses, whatever. Wedding engagement as a contract. All to-do contracts are effectively unbacked promises. When you get engaged to be married, the courts often consider this a contract. If you are jilted, then you can sue for damages, and many courts will grant them. The damages could be anything from the cost of the wedding to the loss of a job given up in expectation of getting married. When the parties agreed to be married, the terms were ill-defined and the damages potentially unbounded. In effect, most of the contract was never agreed to and is being defined by the courts after the fact. Yeah, that's a problem with the courts. That's not a problem with a contract. You can't blame things that don't exist in a contract on the contract. Many courts utilize the theory of reliance as justification for enforcing promises to do things and awarding damages for failure to do things. In theory, only reasonable reliance is considered valid. If someone is unreasonable in their reliance, then it's not enforced. The problem with this approach is that it is circular reasoning. It is only reasonable to rely upon a promise if the courts are going to enforce it, and courts should only enforce a promise if it is reasonable to rely upon it. The problem is that you should just put it in the contract. and not try and make up shit after the fact. Concert singer contract. Imagine someone hired you for $200,000 to sing at a concert. Once you were under contract, they marketed and sold tickets worth $1 million. Now, imagine on the day of the concert you get stage fright, so opt not to sing. The concert organizer may be forced to refund $1 million in tickets, on top of all the expenses of reserving the venue and advertising. If you had sung, the concert organizer expected a profit of $200,000 with expenses of $800,000. But since you didn't sing, the organizer had expenses of just $600,000, but still had no revenue and failed to realize the anticipated profit. All told, the organizer was economically $800,000 behind because of your failure to perform. If taken to court, a judge might make you pay $600,000 to $800,000 plus legal fees on the premise that your failure to perform caused damages. The question is whether it was reasonable to rely upon a promise to perform. No, the question is, put it in the contract. Put it in the contract. Anyway, this reasonable stuff is like subjective dress-wearing judge nonsense. Would you have agreed to sing if you knew the damages you would have to pay for failure to sing? Not without assurances and insurance, right? Sorry, that's me talking. I mean, I'm bouncing in and out of the book in me. I need to be careful with that. Would you have agreed to sing if you knew the damages you would have to pay for failure to sing? Do you even have the ability to pay those damages? If the court ordered payment, could the organizer even collect it? Well, the organizer would need assurances for that if you put it in the contract, and he wasn't an idiot. What we can learn from this example is that the courts can't force you to sing, and even if they could, they couldn't force you to sing your best. Furthermore, if you fail to show up the hour before your performance, no court can hear the dispute in time to compel performance and prevent damages. If it isn't practical to compel performance, what is the alternative? Courts resolve all disputes by transferring title to property from the promise breaker to the other party. If the promise breaker doesn't have property, then the courts authorize wage garnishment. In some cases, courts give the promise breaker the option to perform or pay. This means that all contracts could be written such there is no ambiguity regarding damages, and everything is simply pre-agreed conditional transfer of property. Yeah, that's what I've been arguing this whole time. Put it in the contract. The singer's contract would read something like, if a song is performed, then $200,000 owned by the organizer is transferred to the singer, else $700,000 owned by the singer is transferred to the organizer. In the event of a dispute, a judge or jury would only have to determine whether a song was performed as agreed. If the singer doesn't have $700,000, then the event organizer would need to find an insurer. If no insurer could be found, then the tickets would have to indicate that there is no refund if the singer is unable or unwilling to perform. The audience would end up crowdfunding the insurance. Smarter contracts. Suppose it wasn't possible to transfer the risk to insurers or customers, and the singer didn't have $700,000. This poses an interesting question. Can you contract to transfer title to something you don't own? Imagine the contract. Can you contract to transfer title to something you don't own? Can you agree to pay to transfer title to something in your possession at a future date if you don't currently have it in your possession? Yes, you can make that agreement. For better or for worse on the part of both sides of the contract. People can be ass out. People can be dumbasses. Sometimes they're not dumbasses. Sometimes it's calculated risk. And a lot of times it works out fine. Imagine the contract read, if a song is performed, then the Brooklyn Bridge owned by the organizer is transferred to the singer, else 1 billion tons of gold owned by the singer is transferred to the organizer. The organizer doesn't own the Brooklyn Bridge, and there isn't anywhere near 1 billion tons of gold on the entire planet. Under my interpretation of the title transfer theory of contract, a contract is invalid if under any conditional outcomes a title transfer is indicated for which any party does not have the current title. I don't think that's accurate. Under my interpretation of the title transfer theory of contract, a contract is invalid if under any conditional outcomes a title transfer is indicated for which any party does not have current title. Anything else would be tantamount to a to-do contract where the doing is acquiring title to the assets so that it could be transferred. Yeah, I don't see the issue with that. This interpretation of the title transfer theory of contract has profound implications for almost every kind of contract. We are so used to viewing contracts as promises that it isn't always intuitive to limit contracts to conditional title transfers. Well, I think all contracts are conditional title transfers. So maybe I've got my wires crossed here. Let me continue reading. If you are not careful, it is incredibly easy to fall back into a promise theory of contracts. Even Rothbard fell into this trap in a chapter titled Property Rights and the Theory of Contracts from his book, The Ethics of Liberty. Fortunately, there is a framework that ensures that it is impossible to construct an invalid contract. Smart contracts. A smart contract is effectively computer code that deterministically executes an algorithm based upon the signed statements of individuals. Computer algorithms must be consistent and are unable to assign two owners to the same property at the same time. Anything that can be represented as a smart contract is compatible with the title transfer theory of contract. If it cannot be represented by computer code, then it probably isn't a valid, logically consistent contract. Get a little coffee here. The only thing the courts need to do to enforce smart contracts is to ensure that the physical property referenced by the smart contract is under the control of the owner specified by the smart contract. A smart contract need not be represented in software code in order to be smart. From this point forward, I will refer to contracts compatible with the title transfer theory of contract as smart contracts. Now let's review how Rothbard fell back into the promise theory of contract. Rothbard's mistake was in his example of a loan for $1,000 with a promise to repay $1,100 a year. Let's look at an excerpt from The Ethics of Liberty. Quote, suppose that Smith and Jones make a contract. Smith giving $1,000 to Jones at the present moment, in exchange for an IOU of Jones agreeing to pay Smith $1,100 1 year from now. This is a typical debt contract. What has happened is that Smith has transferred his title to ownership of $1,000 at present, in exchange for Jones agreeing now to transfer title to Smith of $1,100 1 year from now. Suppose that when the appointed date arrives 1 year later, Jones refuses to pay. Why should this payment now be enforceable at libertarian law? Existing law largely contends that Jones must pay $1,100 because he has promised to pay, and that this promise set up in Smith's mind the expectation that he would receive the money. Our contention here is that mere promises are not a transfer of property title. That, while it may well be the moral thing to keep one's promises, that is not and cannot be the function of law, i.e., legal violence, in a libertarian system to enforce morality. Our contention here is that Jones must pay Smith $1,100 because he had already agreed to transfer title, and that the non-payment means that Jones is a thief, that he has stolen the property of Smith. In short, Smith's original transfer of the $1,000 was not absolute but conditional on Jones paying the $1,100 in a year, and that, therefore, the failure to pay is an implicit theft of Smith's rightful property. I'm not sure I like how he said that. Sorry, end quote. I mean, I agree with the theft thing, but I think it's a theft thing not because of the promise, but because if Jones was in possession of $1,100 at the end of the time period, the title of ownership to that $1,100 transferred to Smith. And if Jones refused to hand that $1,100 owned by Smith to Smith when asked, then Jones is literally in possession of stolen property, or in possession of somebody else's property and not giving it to them, which is, like, definitionally theft, right? That's a distinction I would make there. Make sure all the streams are still running. Good. All right. Back to the book. The mistake made by Rothbard is that the title cannot be transferred until the conditions are met. Furthermore, Jones cannot agree to transfer title to $1,100 he does not have. What? Sure he can. The agreement is that X property of Jones transfers ownership on Y date. If he doesn't have any of it to transfer, Smith gets nothing and his ass out. Clauses for handling that stuff should have been added to the contract. You can certainly agree to transfer property that you may have in the future. Why couldn't you agree to transfer property you may have in the future but don't currently have? Happens all the time. And it functions well a lot of the time. The only problem that's missing is that you need to actually put in the contract what happens if you don't own the property at the time you're supposed to transfer it. I don't see this as a problem. Back to the book. If Jones wanted to spend the $1,000 he conditionally received from Smith, then the condition would be a lien that followed the $1,000. If Jones used the $1,000 to buy a laptop from Alice, he would have to disclose that he doesn't have clean title to the $1,000 because he has not yet paid $1,100 to Smith. Alice would have to accept the credit risk of Jones not paying Smith and would therefore make the transfer of title to the laptop contingent upon getting the lien on the money lifted. If Jones failed to pay $1,100 to Smith in 1 year, then Smith retains title to the $1,000 and Alice retains title to the laptop. What? If Jones keeps the laptop, he is a thief. If Alice keeps the $1,000, she is a thief. What? The $100 of interest is an unenforceable promise that only exists as the condition upon which transfer of title to $1,000 may be effected. Titles held to money conditioned on different promises are not fungible. This means that there is no efficient way to use encumbered assets as money. I don't know that scenario with Alice was... I mean, it would, if you wrote the contract to be like that way, it could totally be that way. As long as everyone is consensual, you can, this might be the point being missed. You can consensually be a dumbass and consensually make bad deals and consensually lose money. That doesn't make the contracts invalid. Just makes you a dumbass. So how would lending work under a smart contract? Your contract with the bank will be something like, if required monthly payments are not made, then title to the house is transferred to the bank. No promises are made, just predefined conditional transfers of assets to which the parties have clean title. Normally, recourse bank loans also hold you liable for the difference between what the bank can sell the house for and your loan balance. This arrangement would be invalid because all assets subject to the contract would have to be owned at the time the contract was entered in order to agree to transfer title to those assets. Since the borrower doesn't have the money to pay cash for the house, she cannot sign a contract that transfers title to the cash. Any promise to pay cash should be unenforceable because such a promise could not be implemented in computer code as a smart contract. This means that only non-recourse collateralized loans are enforceable via smart contracts. Why couldn't you write code that just monitored an account for money appearing in it, and then if it saw the money, transferred the money in a future date? Why couldn't that be in the code? Not understanding this objection. And also, so if that's how smart contracts currently work, I mean, that's just the current limitations. We could iterate or innovate on that, right? Make better smart contracts that are able to handle more contingent promises. I mean, I understand that he's arguing for what he would prefer to see in contracts, and that's totally fine. Like, if he wants to make all the contracts in his life in that way, then so be it. And I think he's just suggesting the type of contracts that people should focus on, which is fine. We don't have to agree, but that's fine. We can learn from this. A smart contract on a blockchain is effectively an automated escrow agent which holds title to all assets subject to conditional transfers. Computer code governs how titles transfer based upon how the people involved in the contract interact. A smart contract could be implemented manually with a human escrow agent. A contract's enforceability under a true democracy should be limited to the transfer of assets managed by the escrow agent. The parties to a contract need not hire a third-party escrow agent so long as they personally account for all liens on any property in their possession. In the event of a dispute, a third party can be brought in to interpret the smart contract and evaluate the conditions. Anyone who fails to transfer physical possession after such a ruling is no different than a thief. Under the law of the jungle, you could agree to transfer title to your body in the event you fail to follow through on your contractual terms. Well, that wouldn't be under the law of the jungle, because property doesn't exist there, but I don't think he agrees with that assessment of the law of the jungle. This would allow you to be thrown in prison, forced into a labor camp, or tortured until you comply. At the extreme, you could contract to allow others to kill you. Since your body is practically indivisible, you would only be able to use it as collateral for one contract at a time. Imagine what would happen if you contracted to transfer title to your body in event of default in two different contracts with different people. One person wants to harvest your organs and the other wants to put you in a work camp. Once someone has a lien on your body, it isn't possible to sell your body to someone else or encumber it with additional liens. While such a contract might be possible, a community dedicated to protecting the independence of its members would be wise to not recognize and enforce such contracts. That last sentence, I think, is what I just mentioned a minute ago. He's suggesting what a group of people would be wise or not to do, which is fine. Generally speaking, I would recommend that a community forbid enforcement of any loan with recourse beyond the collateral. This would include unsecured credit card debt. All contracts should be settled by title transfers for which it is impossible to put someone into bankruptcy. Bankruptcy is only possible to the extent contracts were written with respect to assets the parties did not have title to at the time the contract was agreed to. Credit cards could still exist, but the only recourse would be a note on someone's credit rating. This may limit their ability to get future credit, but will not allow creditors to reclaim funds. Property can be conceived of in many dimensions. It has a location in three-dimensional space, but also in time. If you contract to lease a car next week, you cannot double book the reservation because the title in the use of the car at that time is no longer yours. What? That seems to contradict his critique of Rothbard on the previous page. If property has, and I like this description, it has a location in three-dimensional space but also in time. So, yeah, if property exists in the fourth dimension as well, then that seems to say, well, okay, well, we can contract for property title's position in time at a future date with an expectation that it'll be there. And if we fail to predict the future properly, then we need to put in the contract what happens to reconfigure the property at that time. Likewise, you cannot... If you contract to lease a car next week, you cannot double book the reservation because the title in the use of the car at that time is no longer yours. Well, I think all of these are just suggestions, right? You instead of... That's the word that tripped me up. You cannot double book. Well, you can. You can totally do that. But instead of cannot, you probably should have said should. You shouldn't double book reservations because title and the use of the car at that time is no longer yours. Likewise, you, and I'm going to transpose shouldn't, transfer title to money next month until you have the title to that money next month. If a contract conceives of title transfers for assets that may not exist at the time of the transfer, then it should have a fallback. A promise to pay $1,000 next month is not binding unless you have title to it and encumber it with a lien. Property may have an infinite number of dimensions depending on how you divide up usage rights. Time periods are simply one kind of usage right. Let's consider another kind of contract, a non-disclosure agreement. Such a contract would have to read, if information is disclosed, then title to property is transferred. Would you sign a non-disclosure agreement that read, if information is disclosed, then title to $1 million is transferred? First of all, you would have to have $1 million that is not encumbered by other contracts. Imagine that you only had $1 million and you signed a non-disclosure agreement with a 100-year term. Under a smart contract, you would have to lock that money up for 100 years and could not use it for anything that wasn't subject to your ability to disclose information and cause transfer. If you wanted to sign a second non-disclosure agreement, you would need to find other assets to secure it with. If you don't secure a non-disclosure contract with title to assets you own, then it would be an unenforceable contract. In this case, the cost of breaching the non-disclosure contract is only your reputation, i.e. credit rating. In practice, non-disclosure contracts should be restructured as fee for disclosure or have short windows of time during which assets are encumbered. I mean, these are cool ideas for non-disclosure agreements, but I mean, you could totally have date-stamped property transfers. I'm not sure why smart contracts are important for this. Oh, he's just calling smart contracts ones that follow his paradigm. Got it. Okay. Or his suggested paradigm for contracts. Got it. Understood. What about non-compete clauses? Like non-disclosure, it is a meaningless promise only enforceable by reputation damage unless you encumber the title to other assets on condition that you do not compete. An employee with no assets would have very little with which to back a non-compete agreement. However, a large company could back the agreement with equity. Community peace treaties that aim to implement a true democracy should recognize property rights and smart contracts with respect to property title. Furthermore, promises to do things should not be enforced as such, but instead property titles should be transferred subject to pre-agreed objective conditions. It is not reasonable to know how other people are relying upon your promises and what damages they might claim. Therefore, it is not possible to consent to open-ended damages. Without consent, a contract is not valid, nor is the democracy in name only that attempts to enforce it. Absolutely agree with that sentence. It is not reasonable to know how other people are relying upon your promises and what damages they might claim. Therefore, it is not possible to consent to open-ended damages. Without consent, a contract is not valid, nor is the democracy in name only that attempts to enforce it. Well said. One of the greatest innovations of the blockchain industry is the concept of smart contracts. When implemented on a blockchain, a smart contract is a self-executing deterministic agreement among parties enforced by a community without reliance on a credible threat of violence. Traditionally, smart contracts are used with respect to purely digital property because the blockchain has complete authority over its database. Representing all property rights under a software is law mindset provides a useful framework for constructing smart contracts enforced by more manual means. In principle, all agreements should be capable of representation in software, which manages the transfer of title of any and all property based upon relatively objective conditions. Any contract that could not be translated into equivalent code should be considered invalid. A value of trust. Organizing higher order communities on top of the law of the jungle depends upon trust. Without trust, contracts become much more expensive to document and enforce. In low trust environments, many transactions are not even possible because the cost of creating a contract is greater than the value of the transaction. Reputation is the basis of trust, and failure to keep promises will damage reputation and increase everyone's cost of doing business. Contract law should largely be reserved for high-value transactions, and everything else should be unenforceable in the courts. At most, a court or private arbitration system could render an opinion that you broke a promise. That opinion, being public record, would in turn impact all your other business dealings. This should be incentive enough to keep your word without getting into subjective damages. One of the benefits of organizing society according to the rules of relative power in Chapter 4 and Encapsulation, Chapter 5, is that it is easier to build trust in small communities, and that can make these communities more efficient in many ways. Trust is a function of Dunbar's research into the number of relationships our brains can maintain. Trust is largely based upon knowing people, and there are only so many people whom you can know well enough to directly trust. When you heavily rely upon indirect means of trusting people, you risk transferring and concentrating power in ways that can undermine true democracy. In societies where 99% of the people you meet can be trusted by default, things prosper. In society where you can only trust your friends and family, things stagnate. Extensive reliance on a community peace treaty to enforce promises in contracts is already a sign that trust is decaying. In an ideal world, reputation would be highly valued, and therefore trust is so high that written promises are only required to remind the parties of the agreement. In such a society, everyone takes the non-recourse risk that the other party will default. Loans are made without liens being filed at the courthouse. Doors are left unlocked and children play in the streets. We should not attempt to replace trust with contracts, nor enforce promises by courts assessing subjective damages. Ambiguous evaluation of contracts breaks down trust in the peace treaty, quote, government, itself, and yields too much subjective and undemocratic power to the courts. That said, smart contracts in community courts are a necessary background upon which trust can be built. The more predictable court rulings become, the less time people spend fighting in court, and the more quickly people settle things among themselves. Predictable court rulings require a philosophy of contract that is equally predictable. It is for this reason that I believe everyone, or at least every lawyer, should strive for a deep understanding of the title transfer theory of contracts so that they can write smarter contracts. We already live in a society where 99% of contracts are unenforceable. Lawyers cost hundreds of dollars per hour. Navigating the system without lawyers is error-prone and takes months of study. Even if you win in small claims court, 80% of the judgments are never paid. The inability to pay a judgment is another failure of the promise theory of contract. Judgments on smart contracts are either payable or the other party is subject to criminal theft. I will go into more detail on criminal justice in the next chapter. Once you move beyond small claims court, the legal fees start mounting quickly. I was in a business dispute and I was given an estimate of $100,000 in legal fees to enforce a case I felt was open and shut, and that was just my side of the expenses. Despite the obvious facts, the lawyers couldn't give me any reasonable guarantees of winning. Fortunately, we came to a settlement, but only after incurring thousands of dollars in legal fees. Many times in divorces, the cost of fighting over the assets is greater than the total value of all assets of the marriage. In most cases, it makes more sense to suffer a loss than to pursue enforcement of contracts. Once you realize this, you realize that we are already living in a world where the vast majority of contracts are unenforceable. Sadly, one of the biggest reasons for entering a contract today is to attempt to avoid the courts imputing an implied contract in its place. Most contracts spend a ton of ink making it explicit that nothing was promised, represented, or owed. Still more ink is spilled, making sure the customer takes personal responsibility for any and all risks associated with the transaction. In effect, contracts have become about all of the potential unreasonable and unexpected liabilities that could be implied by courts simply by interacting with other people. It is so bad that you cannot even give software away for anyone to use without 50% of the, quote, free software license being about limiting liability. Those last two paragraphs get a resounding yes from me. That is the absurd, you can't compete with this system. That's the problem. You can't make your own arbitration justice system that can compete with this terrible government one that has all these problems he just mentioned. All right, here is the BSD license. This software is provided by copyright holder as is, and any express or implied warranties, including but not limited to the implied warranties of merchantability and fitness for a particular purpose, are disclaimed. In no event shall copyright holder be liable for any direct, indirect, incidental, special, exemplary, or consequential damages, including but not limited to procurement of substitute goods or services, loss of use, data or profits, or business interruption, however caused, and on any theory of liability, whether in contract, strict liability, or tort, including negligence or otherwise arising in any way out of the use of this software, even if advised of the possibility of such damage. Not only does this disclaimer account for 50% of the license text, but it is also in all capital letters. The MIT license also spends about 50% of its text on the same kind of boilerplate. Under a smart contract, all potential liabilities and conditions are explicit. Contracts only get drafted for big-ticket items and are completely unnecessary at all other times. We eliminate a large percentage of economically pointless contracts when everyone knows that a verbal contract is not enforceable and that the courts cannot create implied contracts. Sounds good to me. A society based upon smart contracts completely eliminates the vast majority of the contracts you sign, and the smart contracts that remain are vastly simplified. This simplification of contracts empowers people and disempowers courts. This makes everyone more equal and therefore is a critical component of true democracies. In a subsequent chapter on financial integrity, it will become clear how smart contracts prevent most forms of legalized financial fraud. The next chapter deals with how justice can be had when you are harmed by someone with whom you had no contract. Is the peace treaty a promise or a smart contract? Smart contracts are built upon an assumption of a pre-existing agreement over property rights. Rothbard proposes we agree that the first person to homestead gets assigned the property rights. I propose that property belongs to whoever can control it. That control is subject to physical strength and social strength. Whoa. What he just described is not property. That is the state of nature. That is the absence of property. This is a huge red flag for me. He just defined property as its opposite. Property is an agreement between people to respect each other's property. That creates property. That is a lack of physical strength. And let me read that again and make sure I'm not misunderstanding. I propose that property belongs to whoever can control it. Okay, that's might makes right. That is the absence of property. That is a state of nature. That is, if you're strong enough, then you can come and take my property. That is the opposite of property. That is unproperty. That is anti-property. That is the state of nature, the law of jungle, in using his words. Control is subject to physical strength and social strength. Well, I don't know that social strength exists, but I can kind of see what he's trying to say there, but yeah, hard disagree with that sentence. Surely he's not advocating for might makes right, state of nature. Hard disagree. Two people can agree to recognize property rights, but this agreement isn't a contract. It's a mutual promise built on trust and reputation. The promise is only enforceable by the natural jungle strength of the parties. I don't know that it's even a promise. It's just a reciprocation. Well, I guess it's kind of an agreement. It's just not an explicit one. So I wouldn't. I mean, I guess. But I wouldn't say it's an enforceable agreement, because it's the base agreement that elevates us out of a state of nature. And so if someone doesn't participate in that agreement, I don't go and enforce the agreement on them. They've reduced our relationship back down into a state of nature where it doesn't matter if I use violence, because they've already, by using violence, reduced our relationship back down into that state of nature. Anyway. Word games. Probably only important to me. I don't know. Maybe. It is theoretically possible for a peace treaty to define property rights and contract law by the reliance theory, by the damages theory, or by any other theory of contract. At the end of the day, all that matters is that trust is maintained and people continue to agree to live in peace rather than war. Ultimately, this means that all contracts are based upon the enforcement of the promise made in the peace treaty. We use jungle power to enforce the promises made to reach peace. I think that's a backwards way of looking at it. I think we elevate ourselves with our promises out of the jungle, as he would call it. So why limit ourselves to smart contracts, conditional title transfers, in the peace treaty? Because the peace treaty must be clear, simple, and sustainable. It must be designed to avoid conflict and moral hazard. It must be designed to prevent abuse under the color of law. Any peace treaty that fails in this regard will not last. All other theories of contract have logical inconsistencies evidenced by the inability to represent themselves as computer code and enforce themselves as smart contract. These logical inconsistencies lead to conflict and ultimately to failure of the peace treaty. Conflict transfers power to judges, which ultimately undermines true democracy as the judges become the arbiters of who owns what instead of the people. That last sentence is a very good characterization of how things are today. Not everything is equally life-sustaining. Not all peace treaties are advisable. The purpose of this book is to provide counsel to those faced with negotiating a peace treaty under the assumption that all parties have equal jungle power. It is an attempt to present an agreement agreeable to all parties and biased toward none. Smart contracts are the only logically consistent view of property rights I have come across. How has our current system been working for you? If you have never been to court, then you probably have never actually relied on the enforceability of a contract, nor experienced the insanity created by the current system. We can do better, and I promise you it is worth your time to fully internalize the principles and the power of smart contracts. I want to point out, this is me talking, I want to point out that there are 3 property positions described in this chapter, but he seems to conflate 2 of them and reduce it down to 2 options like we just saw. How do you think the current system's working? Well, that's not working, so mine is the alternative. Well, there were 3 that we described, like Rothbard's, the current one, and his. And I think he successfully critiqued the current one, but maybe not so much Rothbard's. Yeah, but what about? I have presented the smart contract approach to contracting to many people and have gotten a lot of feedback. We are so used to viewing contracts as promises that we cannot imagine a world that relied only on smart contracts or reputation. Things appear to be working as is, so why should a book about true democracy advocate such a fundamental change to every business arrangement? Can't we keep a promise theory of contract and still adopt the other principles of true democracy? To make contractual promises enforceable beyond a posted bond is to imbue them with the characteristics of property. My promise to pay you $1 trillion becomes an asset on your books because by law, if I fail to pay, the government is supposed to make me pay. Everyone should know that I don't have $1 trillion nor ability to earn it, and that there is nothing the government can do to enforce this contract. The damages one seeks from broken promises must come from somewhere. If there are no assets to back the promise, then the promise has potentially no value. And this is me talking, and that's okay. Don't accept dumb contracts. Any accountant worth their salt knows better than to count their chickens, promises, before they hatch. If a promise to pay $1 trillion I don't have is obviously not a valid contract, then at what point does a promise, well, no, I say it, it is a valid contract. I don't see why it's not a valid contract. It might be a dumb contract for somebody to depend on. Then at what point does a promise become valid and therefore enforceable? $1 billion, $1 million, $1,000, or $1? The fact that promises should not be considered enforceable should be obvious for anyone doing business with the poor. No matter what contract a poor person signs, if they don't keep their promise, there is nothing you can do to collect damages. You can't get blood out of a turnip. The consequence of enforcing promises as opposed to conditional title transfers is to encourage people to build their economic house on a foundation of sand. It enables fraud by transmuting something that should have no value into something that is presumed to have value. Let me read that again. It enables fraud by transmuting something that should have no value into something that is presumed to have value. Okay, you cannot make the claim that it should have no value objectively. Value is subjective. So if people value it, then it has value. There is no should in the universe that makes that statement, that can make a statement, a prescriptive statement like that, valid. An insurance company makes promises to provide a level of coverage that they mathematically cannot keep in certain circumstances. Those relying upon that promise will be disappointed when their insurance company goes bankrupt when they need it most because they misestimated the frequency and magnitude of potential claims. Manufacturers make promises to provide a warranty. We assume these promises are worth something because people perceive companies to be big and rich compared to their customers. The problem is that in order for a company to make good on its promises, it must set aside capital to self-insure against defects. This capital must come from the customers in the form of increased prices. Because the manufacturer cannot possibly know the magnitude of potential claims nor the liability, they will either end up overcharging or overpromising, and neither the customer nor the manufacturer knows the reality until the end of the warranty period. From this perspective, a lifetime warranty is an unbacked and therefore potentially unenforceable promise. A company promising a lifetime warranty is selling you a bill of goods unless they are setting aside segregated funds to back the warranty. Due to fierce market competition and price-conscious customers, companies often find it cheaper to provide unbacked warranty promises and hope for the best. Try collecting on a lifetime warranty from a bankrupt manufacturer. Banks make promises to pay on demand, but if everyone attempted to collect on that promise at the same time, the bank would be insolvent. How is this a valid contract? How can the governments enforce such a contract? They can't and they don't. Imagine you signed 1,000 contracts for various things. In each contract, you have the ability to pay the potential damages, but only if you don't default on any of the other 999 contracts. How is this different than fractional reserve banking? Are your counterparties aware of the risk that you may not be able to pay damages if you fail to keep your contractual promises? Yeah, that stuff on banking was very well said. Even under the promise theory of contracts, a contract must have the consent of the parties to be considered valid. In order to consent, one must have knowledge. How can one have knowledge of the extent to which failure to perform a promise will harm the other party if you must wait for a judge to assess damages after the fact? If you do not know the limits on your liability, then how can you consent? If you lack the ability to pay the damages as outlined in the contract or awarded by a judge, then how is a government to enforce it? The supposed contract is invalid to both sides. One side is unable to consent while the other side is unable to collect. A true democracy should facilitate people working together and building trust. The consequence of defaulting on promises is a loss of trust. We must all take personal responsibility in determining who to trust and bearing the cost of misplacing our trust. If we allow promise-based contracts to be enforced with the full jungle power of the community, then we introduce moral hazard at the most fundamental level. We allow one person to take the risk of trusting someone and expecting everyone else to bear the cost of enforcing the collection of damages when that trust was misplaced. The consequence of this is to cause members of society to grant trust to people who do not deserve it. This is because people aren't trusting each other. They are trusting the illusion of an enforceable contract. Never do business with someone who you do not trust. If trust is lacking, then a smart contract is how a community should document an enforceable contract. If a contractual promise is broken, then your only recourse should be to warn others about the breach. Okay. Next chapter. Democratic justice. Should be spicy. Let's see. Part of achieving democratic consensus is dealing with those who violate the peace treaty. A society must first agree on rules, then agree on a process for identification of violations, and a society must first agree on rules. Yeah, okay. Sounds good. Then agree on a process for identification of violations, and finally a process for restitution or retribution. How should we go about designing such a system? What would a wise and fully independent individual negotiate? What would a wise and fully independent individual negotiate when joining a true democracy? Remember, we should not let the status quo bias our view or limit our perspective. Before signing any contract or peace treaty, you must always ask yourself, what is my worst case outcome? Imagine you were the person in jail or sentenced to death for a crime you didn't commit. What incentive structure would you want motivating everyone involved in your prosecution? What incentives would you want to motivate others to prove your innocence rather than your guilt? These are important questions to consider when you are negotiating a peace treaty in a truly democratic society where presumption of innocence should be maintained. After all, would you sign a peace treaty where you were presumed guilty until proven innocent? You can't prove a negative, so choose wisely. There are three sides to every justice system: the side of the victim, the side of the accused criminal, and everyone else who may be footing some or all of the costs. If the incentives involved are misaligned, then you get moral hazards. Ideally, the same logical person or entity would be responsible for the cost to the justice system, the damages from the crime, and the cost of mistakes in justice. When this is true, this single person or entity can make practical trade-offs between buying insurance, letting things go, investigating, prosecuting, and the cost of punishment or rehabilitation. When different people are responsible for costs and decision-making, then either crime will be too high, penalties too expensive, or innocent people wrongfully harmed too often. Someone will be systematically benefiting at the expense of others. In the worst case, moral hazard creates positive feedback loops which cause expenses to rise, restitution to fall, the rate of catching criminals to fall, and wrongful imprisonment to increase. Our traditional system is close to the worst case. Before considering a new system, let's take a look at the unjust nature of current, quote, justice systems from the perspective of a libertarian. When most people think about a justice system, they envision police, courts, and jails. Everyone wants justice, and we're told over and over again that justice is what police, courts, and jails produce. But is this really the case? When you are harmed, you want justice. To be more specific, you want a fair outcome, and that usually means receiving restitution, compensation, from the party that harmed you or an insurance company. Punishment of the bad behavior has a cost and does nothing to restore the victims of crime. At best, punishment acts as a deterrent to crime, but it is worthless after a crime has already been committed and therefore irrelevant to justice. Fairness is something that cannot be defined in absolute terms because everyone has a different opinion about what is fair. In general, there is only one means to establish what is fair: voluntary trade. Absent voluntary trade, you always have one person who feels they've been harmed and therefore treated unfairly. Lack of voluntary trade is where our modern justice system ends up producing more injustice than justice. Let's imagine that Alice, someone you don't know, has her house robbed while she is on vacation. Alice wants justice. She wants her stuff back and the person who stole it to compensate her for the time and distress they caused. At this point, we have one injustice caused by the robber. Alice, in pursuit of justice, comes to you and asks that you help pay to hire a detective to track down the thief. She argues that you could be robbed next and that she cannot afford to do it herself. You get to thinking about it and then decide that it would be cheaper for you to lock your doors and adopt a cryptocurrency than to hire a detective for Alice. She goes door to door and is unable to find anyone willing to help her. Frustrated, Alice goes home, finds a gun, and goes door to door demanding everyone contribute a small amount to her cause. At this point, we now have many injustices. Alice has become guilty of the same crime for which she demands justice. In some ways, she is guilty of a far worse crime because she is threatening to kill anyone who doesn't help her. Most people cave to Alice, but one guy resists paying and is killed while resisting. Alice feels this is necessary because otherwise crime would get out of control, and she rationalizes that the guy who resisted paying is guilty of helping the robber, accessory after the fact, harboring a fugitive, interfering with an investigation, yada yada. The challenge is that just because Alice has experienced an injustice at the hands of another does not mean that she is granted a right to harm others. Instead, she must find a way to get justice without causing injustice to innocent parties. This could be resolved by the peace treaty, defining everyone's obligation to contribute, but how should such a treaty be structured to prevent abuse and moral hazards? What? Hold on. This could be resolved by the peace treaty defining everyone's obligation to contribute. Or not. But yeah, it would be a good idea to have one where people worked together in ways to contribute. But voluntary, right? After all, under the current system, the taxpayer is forced to pay for the investigation, the trial, the punishment, and the liability for wrongdoing, regardless of the quality or effectiveness of the system. Politicians benefit from sounding tough on crime. Lawyers benefit from having more crimes and more complicated processes. Prison operators benefit from longer sentences, and prosecutors benefit from high conviction rates rather than high rates of justice. None of these people suffer the costs of their mistakes. There is a multitude of people who have control over how other people's money is spent and benefit from that control. Moral hazard is everywhere. Well said. Ensuring against injustice. Alice decides to resolve her internal contradiction by finding an alternative to violence. She buys insurance so that if she happens to be robbed in the future, she will have the ability to hire a detective to track down the criminal, a court to try the criminal, and a prison to detain the criminal. So Alice starts shopping around and finds out insurance for our current system is extremely expensive. Obviously, I haven't done the exact probabilistic number crunching that an actuary would do, but I presume that the cost of police patrols is similar to routine medical checkups. The cost of a trial is similar to an emergency room visit, followed by multiple days of hospitalization. The cost of imprisoning someone is similar to the cost of long-term care in the event of cancer, and that the cost of malpractice insurance is similar to the cost of insuring against wrongful imprisonment. That is a really cool thought experiment for the costs of a voluntary justice system. Interesting. I then presume that the risk of being a victim of a crime is similar to the risk of a major medical expense. If you were to attempt to purchase medical insurance with 0% copay and no limit, then you would quickly discover the cost is very high. The cost of the insurance would be even higher given the moral hazard created by mandatory coverage and inability to group by risk profile. Like modern medical insurance, the costs would rise higher than most people would be willing or able to pay. The problem with our justice system is that expenses are socialized, and no one really knows the full cost of the system, especially when you account for opportunity costs and errors. If people had their insurance rates go up every time they called the cops and started an investigation, then people would call the cops less often. If people had a copay on prosecuting a criminal, then many wouldn't bother to press charges for petty offenses. Everything changes as soon as someone else is paying the bill. It gets even worse when the government gets to define crimes without victims. It would be like giving doctors the right to make up diseases and then force treatments on people who never came in to see them, while having the insurance company pick up 100% of the costs. Damn, that was really, really well said. Really, really well said. I love that. One study found that people would be willing to pay up to $12 million if it could stop a murder. I'm going to assume the study used flawed economic reasoning, asking opinions instead of observing actions, when they attempted to estimate the individual demand. But I do believe that people are willing to spend $12 million of other people's money to stop a single murder. And this is the heart of socialism and moral hazard. Imagine if those who chose to use our criminal justice system were responsible for 100% of the bill. I think you would find that no one would be in prison unless they were mentally ill and posed a very high probability of a future threat. The cost of keeping Very well said. I'm going to say that again. Imagine if those who chose to use our criminal justice system were responsible for 100% of the bill. I think you would find that no one would be in prison unless they were mentally ill and posed a very high probability of a future threat. The cost of keeping people in prison for decades may be far higher than the cost of a potential wrongful death. Theft, fraud, drugs, and even many murders may not result in prison. With the rare exception of serial killers who murder for the joy of it, there is little reform or deterrence actually occurring by throwing people in prison for excessive terms. So far, my arguments have been almost purely utilitarian. People would not voluntarily pay for the system we have today if it was funded by insurance premiums. Assume that everyone had a minimum insurance premium to cover bodily harm, and that premiums increased based upon the value of the goods insured against a crime. At a certain point, it makes more sense to just insure the loss than to prosecute the loss. At a certain point, hiring private security guards is cheaper than increasing police patrols. Some people would rather just rely upon medical insurance and not pursue their mugger. The question becomes, at what point does everyone opting to forego justice in favor of loss insurance reduce the probability of getting caught so far that crime spikes? As crime spikes, insurance premiums for losses will increase, and it starts to make sense to invest in investigators to hold people accountable. Like all things in life, there is a balance. The cost of catching criminals approaches infinity as you attempt to catch 100% of all criminals. The cost of insurance approaches infinity as criminals go without accountability. In a competitive market, insurance companies would have incentives to track down criminals as efficiently as possible. They would also have incentive to set punishments high enough to deter crime, but low enough to keep their insurance premiums competitive in the market. Research has demonstrated that the probability of getting caught is far more important than the severity of the punishment. If the profit from a crime can pay for the insurance against getting caught, then there is no longer any risk to committing the crime. Insurance costs are largely driven by the ratio of those who never file claims to those who file claims. Stated another way, the lower the probability of getting caught, the cheaper the insurance for the criminal will become. If you can steal $100 with a 10% chance of getting caught, then, as long as the restitution and penalty is less than $1,000, the criminal will still profit on average. Some crimes, like copyright infringement, have such a low probability of getting caught that millions of people routinely violate copyright laws. When it comes to penalties, there is diminishing marginal utility in deterrence. The first day in jail has a huge deterrent value relative to the 10,000th day in jail. However, the cost to those paying for the prison is the same for all 10,000 days. If all crimes carry the death penalty, then once you run a stop sign, you might as well attempt to kill the cop that pulls you over. In other words, consequences that are not proportional to crimes can motivate increases in quantity and severity of crime. For people over a certain age, long prison sentences may be perceived as worse than death. For people with 1 month to live and additional prison time, additional prison time is no longer a deterrent. The challenge a community faces is doing this cost-benefit analysis in a way that doesn't fall victim to tragedy of the commons. After all, some people want long punishments, but only because they only have to pay 0.0000001% of the cost. When you consider that your taxes are more likely to be wasted somewhere else than refunded, there is no perceivable cost to the taxpayer for long prison sentences. Others want long punishments because they operate, are employed by, or otherwise financially benefit from the prison system. If the justice system were operated as competition among multiple insurance companies, and these insurance companies were liable for compensating victims of crime and paying for the cost of finding, prosecuting, and setting punishments of criminals, then the incentives are aligned properly. Any insurance company that was too lax on catching criminals would have premiums rise. Any insurance company that spent too much on investigating or punishment would see premiums rise. Any insurance company which wrongfully convicts someone would have liability which should show up in increased premiums. Each individual would then have a choice on which insurance company they should adopt, and this would make participating voluntary and democratic with minimal moral hazard. This is vastly different than today's dino justice system, where those who decide how much to spend on catching and punishing criminals are not paying the bill, nor are they liable for their mistakes. Decisions are made by voters casting votes that cost them nothing, because their vote is unlikely to have any statistical impact on the outcome. If you keep the entire premise and structure of our justice system and simply remove the tax subsidy, then few would choose to pay to use it. They would find an alternative that was more effective and cheaper. Socialist justice cannot work. One problem we have in our society is that people have adopted a punishment mentality when it comes to crime. When someone is robbed, the state might catch the robber, but will rarely make the victim whole. The robber is rarely even held liable for the cost of his own incarceration. Even if we held robbers liable for the cost of their incarceration, they more often than not lack the ability to pay. It is easy to promote punishment when you're not the one who has to pay for that punishment. Do we really want a policy of socialized revenge? Does revenge even stop crime? It is like punching yourself in the face to spite your nose. You end up harming yourself more in the pursuit of revenge. When you allow society to socialize the cost of revenge, you don't even feel the pain. Everyone else does. Ludwig von Mises, in his paper, Economic Calculation in the Socialist Commonwealth, outlined the primary reason socialist institutions cannot function. They lack the ability to economically allocate resources. Without price feedback, the bureaucrats who set the prison sentences and the politicians who make the laws have no measure of profit and loss to society. For them, longer sentences and more laws always help them get elected and gain more personal wealth and power. Those that press charges have no problem calling the police over the loss of $1,000, despite the cost of the police investigation, trial, and punishment being over $100,000. That $100,000 comes from other people who are now also denied access their money, and all the while, the original victim is not even reimbursed. When someone has been harmed, it is normal for people to lose all rational thinking. In their anger, they are willing to go on a rampage and exact a punishment greatly disproportional to the crime because it will make them feel better. Give someone a gun after they have been harmed, robbed, or violated, and an opportunity to shoot the other person without consequence, and many will take it. When you have a socialist justice system, all of the emotions and irrational behavior gets expressed by excessive spending on bureaucratic trials and excessive punishments that ultimately do little to reduce crime. A community that is negotiating a peace treaty would be wise to consider how it manages its justice system. The use of political playoffs to select judges and generate laws will go a long way towards minimizing the corruption of the current system. However, even if we had higher integrity people running our current system, it would still suffer from many problems of moral hazard. Under today's system, when a prosecutor, judge, and jury make a mistake, it is either the taxpayers or the wrongfully punished individual who pay the bill. This creates a huge moral hazard, where a prosecutor attempts to maximize her conviction rate rather than her justice rate. After all, an accountant can easily see the costs of all of the failed convictions. But how does one account for wrongful convictions? The cost of wrongful convictions isn't discovered until years or decades later, and only in a small fraction of the cases. The prosecutor has likely moved on or retired. What incentive is there to clear your name after you have served your term? It will only cost you money and won't make you whole. The purpose of the peace treaty is to define the process for fair trials and judgments. Once a process is defined, it is the responsibility of the people or the insurance companies to pay the cost of operating the process. This prevents rogue insurance companies from seeking unjust sentences because they would still have to pay for a fair trial, judged by a representative of the people, with a random jury of your peers. The random jury. Random is in italics. The cost of, and would be a big change from what we have today, right? Where voir dire totally manipulates the justice system on a whole other level. The cost of paying restitution for a wrongful punishment is often greater than the cost of letting the original crime go unpunished. The only person in a position to judge the risk... Hold on, let me think. The cost of paying restitution for a wrongful punishment is often greater than the cost of letting the original crime go unpunished. The only person in a position to judge the risk is the person asking for the punishment, and therefore assuming liability for the wrongful imprisonment. If someone wants to collect restitution and apply a punishment, then government force is being used for their benefit, and therefore they should be responsible for paying the insurance premium of wrongful imprisonment. Interestingly enough, an insurance company would likely want to evaluate the facts of the case before telling the victim the cost of the wrongful prosecution insurance. The more ambiguous the case, and more severe the punishment and restitution, as judged by the insurance company, the higher the insurance premium will be. The victim could have multiple insurance companies bid to keep the costs down, but this would also drive up costs, as each insurance company would need to cover the cost of reviewing the facts to submit a bid. To be punished for a crime now requires being convicted by a jury of your peers, an insurance company, and the victim's ability and willingness to pay for insurance. If a crime is particularly bad and the victim is unable or unwilling to pay it, it would be up to the people to raise donations to pay the wrongful imprisonment insurance premiums. In all likelihood, an insurance company or group of insurance companies would pay the cost of imprisoning those likely to commit offenses again, even if the victim was uninsured. After all, the insurance companies are responsible for all the costs of reimbursing future victims, catching the criminal again, and prosecuting them again. Perhaps the most important factor of this arrangement is that without a victim, there is no one to find you guilty and to pay the insurance premiums, and therefore there is no crime. Furthermore, it wouldn't make any sense for the legislature, elected by the people via political playoffs, to pass a victimless crime law. Even if they passed a law without a victim, it would be up to the people to fund the enforcement of that law from personal or insurance funds rather than community taxation. The willingness to fund the enforcement is evidence that someone feels the action has caused sufficient harm to justify the personal expense. Putting an end to victimless crimes would go a long way to reducing costs. That was an excellent think-through on justice in a free society and how the costs could work to provide a much better, more balanced system. That was really neat. When it comes to punishment, it usually makes sense to leave an incentive to stop a crime spree. If your first murder condemns you to death, then you will commit as many murders as necessary to avoid getting caught. Turning yourself in should be rewarded. There is no one-size-fits-all approach, which is why we need properly aligned market incentives. Summary of a proposed democratic justice system. Moral hazard must be avoided as much as possible to prevent the justice system from spiraling into out-of-control corruption. Trade-offs must be made between insuring against loss, investigating crime, the cost of punishment, and risk of wrongful punishments. The purpose of government should be to define a fair process to authorize the use of violence and transfer of property, but the costs associated with following that process and the liabilities for mistakes in that process must be on the people utilizing and benefiting from the process. When someone or their possessions are damaged, they file a claim with their insurance company. The insurance company does a quick verification of damage claims and then makes them whole according to the terms of the policy. The insurance company now has a claim against the criminal and can choose the most cost-effective means of pursuing the criminal, or can choose not to pursue. Once the insurance company identifies the guilty party, they make an arrest and start accruing risk of wrongful imprisonment. Once an arrest is made, the trial begins. The court is governed by 3 judges randomly selected from among the top leaders in a political playoff process. The cost of the trial is paid for by the insurance company. The arrested individual can either defend himself or be defended by an attorney appointed by his insurance company. The plaintiff's insurance company would post a bond payable to the defendant's lawyer insurance company in the event the trial fails to get a conviction. This bond requirement is how public defenders are compensated, and the magnitude of the bond should be proportional to the penalty sought. Seeking a death penalty would require a massive bond. Seeking a fine would require a bond proportional to the fine. Game theory can be used to prevent the prosecution from seeking unreasonably long punishments. Imagine if the penalty sought by the plaintiff must be declared in advance and cannot be reduced by the judges. The judges must find the person guilty and the penalty reasonable. If the penalty is too harsh, such as seeking the death sentence for shoplifting, then even if the defendant is found guilty of shoplifting, the case is dismissed and cannot be brought again. This is like asking the plaintiff to divide the cookie, punishment versus freedom, and the judge to choose which side is fairer. Furthermore, the cost of the penalty must be put in escrow when the charges are filed. So, if a 5-year prison term is sought, then the money required to fund 5 years of prison must be paid up front. All of these things taken together create a systematic bias toward the presumption of innocence and against the justice system, creating more injustice. In the event of a wrongful conviction, the victim can file a case against the prosecuting insurance company. This case would follow the same rules as any other crime. It would be as if a criminal kidnapped you and locked you in a basement for years. From the perspective of the innocent, there is no difference. Ah, man, that was good stuff. Really good stuff. That is a big part. That's another huge thing that this justice system we're currently subjected to is missing. When they put you in jail wrongfully, they suffer precisely no penalties. They literally abduct you, cage you, hold you against your will, hold you hostage, control your, abuse you, all kinds of things. If you're innocent, all of those things are crimes which they are held precisely blameless, and just nothing happens to them. Criminal corporations. Society is composed of people, and only people can act or commit crimes. Under a true democracy, all companies are nothing more than a collection of people with contracts among them. These contracts can transfer liability, but cannot limit it nor convert it from prison time to a fine. So, if a company is convicted of a crime worthy of the death penalty, then someone will get the death penalty. That someone will be determined according to the contracts involved. Employment contracts and shareholder agreements will identify who has liability. Suppose a drug company knowingly pollutes the water supply, and as a result 100 people die. This is no different than if a group of criminals knowingly poisoned other people. Everyone who is complicit in the pollution is potentially liable, and the existence of contracts among these people does not transform the criminal act to be by the company instead of by the co-conspirators. You cannot shield yourself from the death penalty or prison time by contract. A criminal company is just organized crime. Should the leader and employees of the mafia transform all penalties into fines by contract? That would completely undermine the justice system. Likewise, if a common shoplifter is required to serve jail time for stealing a couple $1,000s, how much time in jail should someone operating on behalf of a company stealing billions serve? Is it sufficient for just the CEO to serve time? Imagine a shoplifter operates for years and divides the loot among 1,000 people. One day the shoplifter is caught but no longer has the loot. Is it sufficient to put the shoplifter in jail, or should all 1,000 people be put in jail? Should government grant shareholders limited liability, which allows them to keep the dividends from years of theft? Why should the penalty for a shareholder be limited to a fine, but a sole proprietor goes to jail? Would you invest in a company if any prison time earned by the business had to be served pro rata by the shareholders? An imbalance in criminal liability between shareholders investing in a criminal enterprise and ordinary people undermines true democracy by creating an imbalance of power. This imbalance favors organized crime. A wise person negotiating a peace treaty under the law of the jungle should think twice before agreeing to such terms. Prisoner's dilemma of ransom. A fair justice system requires a process people trust, paid for by those with incentive to balance all of the trade-offs that must be made. Moral hazards and prisoners' dilemmas, no pun intended, abound when it comes to designing the process. Consider the issue of ransom. Criminals profit by stealing valuable property or loved ones and holding them for ransom. The criminal has economic incentive to price the ransom so that they are likely to be paid and high enough to offset the risk of getting caught. If no one ever paid a ransom, then this kind of crime would never happen. To the extent that some people occasionally pay ransom, criminals are more likely to attempt it. Paying ransom is like turning on your fellow citizens in the prisoner's dilemma. A society looking to stop ransom would make it illegal to pay ransoms. Paying the ransom would make one complicit in the crime, a co-conspirator? This could make you a co-conspirator in kidnapping or potentially attempted murder? What? No? Who would be your victim? That's absurd. That would be a victimless crime. Let me read that again. Paying the ransom would make one complicit in the crime. A co-conspirator. This could make you a co-conspirator in kidnapping or potentially attempted murder. I think that's completely absurd. You're under threat. Someone you love is under threat. Yeah, I cannot square that circle even to make an argument for him. You could attempt to arrange a payment in an effort to catch the criminal, but this would require reporting the ransom attempt and taking measures to ensure the kidnapper is unlikely to get the payment. The more severe the penalty for paying ransom, the harder it is for both the criminal and the victim to successfully complete the crime. The presence of prisoners' dilemmas is why a society needs to cooperate to form a peace treaty, and why rules are required. The need for rules and rule enforcers is why a true democratic process is required. Without a true democracy, some of the people did not consent to making the rules, and everyone suffers from the resulting moral hazard. Nothing is perfect. The justice system proposed by this chapter is incomplete, and certain to have its own shortcomings. The important takeaway is that the status quo is broken at a fundamental level due to systemic moral hazard and misalignment of incentives. The principle of aligning the cost of crime, cost of insurance, cost of investigation, cost of prosecution, and cost of errors into one organization must be a component of any system that aims to minimize corruption and costs. The principles of true democracy can be applied to select judges and juries in a way that prevents anyone from turning the courts into legislators ruling from the bench. The proposed justice system builds on top of the principles of smart contracts. In a subsequent chapter, I will outline the principles of insurance under smart contracts, which any justice insurance should be compatible with. All right. Just kind of scanning ahead. I think we will continue some more today. The next chapter is financial integrity. Financial integrity is a structural property of institutions which are immune to bankruptcy. In this case, bankruptcy is defined as a default on contractual terms. Using smart contracts, all contractual obligations are resolved by pre-agreed title transfers, and unbacked promises are not legitimate. In this chapter, I hope you will gain insight into the subtle nature of the fraud baked into commonly accepted financial arrangements. A society that allows systemic fraud will not maintain its status as a true democracy, and if you are to negotiate a peace treaty, then it will serve you well to understand the principles in this chapter. The most straightforward way of understanding a lack of financial integrity is a hotel that leases the same room to 10 different guests at the same time. In this case, each guest thought they had purchased the right to use a scarce resource, a hotel room, but when they show up to use the room, they discover someone sleeping in their bed. For the purpose of this chapter, I'm using hotel rooms because they are concrete, easy to visualize, and the damages from fraud are obvious. Once we have established the structure of various frauds, it is my hope that you will be in a better position to see the systemic fraud in other industries. I will demonstrate how these same kinds of frauds occur throughout our financial system in everything from commodities to stocks to cryptocurrency exchanges and banking. You may have even experienced these kinds of frauds in a rental car or airline reservations. Mark Twain once said, quote, "It's easier to fool people than to convince them that they have been fooled." This is a natural bias we all have towards decisions we have already made. If you have already acted on false information, then you will have a harder time convincing yourself that the information was false. Yeah, that was really good stuff. It's called the sunk cost bias. We have all been interacting with fraudulent business practices for so long that we no longer see the fraud and have a hard time accepting it as fraud. I ask that you set aside any preconceived justifications for the status quo business practices. Borrowing short and lending long. Suppose someone rented a room from a hotel for one night, then subleased it to someone else for 30 days with a big upfront deposit. The next day, the hotel would attempt to lease the room to another guest, and there would be an immediate conflict due to two people both thinking they had a claim to the same room. The individual who subleased the room for 30 days committed fraud by attempting to profit on the spread between 1-day and 30-day lease rates. And taking a deposit, they had hoped they could continue to lease the room 1 day at a time for 30 days, and no one would ever catch them. This is known as borrowing short-term and lending long-term. The principle of this example is that if you only have the right to use property for a fixed period of time, then you cannot make contracts with respect to that property beyond that time. Okay, I'm back to the same response. Well, you can make that contract, but you might get fucked. You might end up defrauding somebody. A contract can still be a valid contract, even if it's dumb or dangerous or irresponsible or might lead to severe consequences to you. And by dumb, I mean dumb for both people. Dumb for the person to do and dumb for the person signing the contract on the other side. Like, for example, it would be dumb for me, if it was an important, to use the hotel room example, to limit myself to the hotel room example. If I'm going to need that hotel room, I'm going to need to verify with the actual owner of the hotel room that there are no other constraints on that hotel room for the amount of time this other guy is trying to lease it to me for. And if I signed it anyway and got screwed, that means dumb on both sides. And if I want damages, I need to put the damages in the contract. And if I want damages if the fraudulent party is unable to pay, need to put the contingencies for that on the contract too. Over leasing. A hotel owner notices that on average 10% of his guests never show up to claim their room. Based upon this knowledge, he decides to lease 5% more rooms than he actually has. This realizes an immediate increase in profit for the hotel owner, but also violates the principles of smart contracts. The fraud is exposed on that fateful day when Caesar orders everyone to return to their hometown for a census. Guests show up and fill all the rooms, and the late arrivals discover there is no room left at the inn. One such late arriving couple reserved in advance because they were pregnant and wanted to be sure they had a suitable room. Because the hotel owner sold more leases than rooms, this poor couple was forced to stay in a barn. The hotel owner profited by lying to other market participants about the availability of his rooms. Had he been honest and told this pregnant couple that he was sold out, they could have made arrangements at another nearby hotel. Instead, they showed up and discovered that not only is their prepaid reservation not available, but all other hotels are also booked. At this point, the cost of getting a replacement room is far higher, potentially infinitely higher. A monetary refund is unable to make the couple whole, and their baby is born among animals greatly increasing risk of disease and or death. The principle of this analogy is that you cannot sell or lease what you do not own, even if the odds of getting caught are extremely long. And again, Patrick responds by saying, well, you can, you just might get infinitely fucked. Put fail clauses in your contracts. It's not fraud until there's a victim. You can't defraud no one. That's the break in the logic there. It's not fraud until the person shows up to the room and you've given a room to somebody else and don't have a room for them and you've broken your contract. Now it's fraud. Now there's a victim. If and when and until that happens, it is not. Treating different kinds of rooms as equal. Imagine if a particular hotel has two different kinds of rooms, those with a view and those in the basement. This hotel makes reservations for each kind of room at different prices, but when people show up to claim their room, the hotel declares, with government approval, that all reservations are equal, and a couple expecting the honeymoon suite with a view gets stuck in the basement next to a noisy machine room. This fraud serves the hotel because they can reserve more rooms at higher rates by advertising a view than advertising a basement. The hotel owner would fill all the basement rooms first, even if rooms with a view were available. The principle is that contracts must not treat two non-fungible assets as fungible, interchangeable, or indistinguishable. All kinds of qualities can make two assets non-fungible, even if normally they are the same price. For example, imagine that on a typical day all rooms are equal, but during extreme rains some rooms can flood, whether from water table or roof leaking. Meanwhile, other rooms are dry all the time. When the sun is shining, the hotel is able to lease all rooms for identical rates, but when it's raining, some rooms cannot be leased at all. The hotel owner rents all rooms as guaranteed to be dry. Effectively, the hotel owner is pretending all rooms are fungible because they all have the same price today. He assumes the sunny day. This allows the hotel to charge more for rooms. But then some guests show up to a damp or even flooded room. If the hotel accurately advertised some rooms with a 25% chance of dampness, then it would have to charge less all the time for those rooms and indicate that there are indeed two different kinds of rooms. The principle here is that differences in risk represent differences in kind and value. You cannot treat two things as equal and fungible just because 99% of the time they fetch the same market price. The fine print. One hotel owner recognizes that it would be fraud to write contracts in such a clearly fraudulent manner, so he adds a clause to all of his contracts that allows him to cancel the reservation by refunding the money, plus an inconvenience fee. He then goes about business as usual, overbooking, false advertising, leasing short, lending long. In the event that his not a fraud is about to be exposed, he simply makes a cash payment according to the pre-agreed terms of the contract. Even if he occasionally pays a fee, he is still more profitable on average. Most customers are not lawyers and don't have the time to read all the fine print. The pregnant couple will feel cheated when they don't get the room they reserved, even though the fine print declared all obligations met. The principle here is that a contract must be a meeting of the minds, based upon the expectation of the parties. Yeah, and I think I disagreed with Kinsella a little bit on that meeting of the minds stuff. I could be wrong. Maybe I'm misremembering the conversation with Kinsella, but I find this idea of a contract must be a meeting of the minds, that is subjective, unknowable nonsense, and is nothing to base a contract theory on. Especially not one that we just spent like 20 pages, talking about contract theory that needs to be more explicit. And now we're gonna backtrack and say, oh, it can just be a meeting of the minds. What does that mean? How do you verify a meeting of the minds? Can't. Language is subjective. Interpretation of language is subjective. You can't verify that. What you can verify is the fine print, like it's written there. So if anything, that should have more weight. It's more objective and verifiable. For example, even if the pregnant couple read the contract and noticed the fine print regarding the buyout provision, they would naturally assume that the hotel owner was merely covering events beyond his control. If the hotel disclosed its practice of overbooking, then a pregnant couple could easily request a guaranteed reservation that was not overbooked. After all, they had a long drive. They knew that everything would be booked, and they knew they would be the last ones to arrive. At this point, the hotel owner could say, "Sorry, we don't offer those guarantees." So the couple shops around to other hotels and discovers that all hotels overbook and none will make guarantees. In fact, all hotel owners have formed a cartel and prevent any hotel from making such guarantees. Even without a cartel, because of overbooking, the fraudulent hotels are able to offer lower average room rates and may drive the honest hotels out of business. The end result is that all hotel owners get to increase their profits while their guests take all the risk of not having a place to stay when they need it most. A refund plus inconvenience fee can hardly cover their loss and opportunity costs, especially if your baby dies from being born in a barn. To add insult to injury, imagine that instead of a refund, the hotel simply gave you credit for a future date. At a bare minimum, the hotel should be offering to cover the cost of finding them a room, which could mean putting them up at the nearest hotel with an empty room or finding another guest that is willing to give up their room for a fee. Even if the hotel owner is able to scramble and deliver a comparable room this time, it doesn't negate the fraud. The fraud was embedded in a contract that would be impossible to implement as a smart contract. I don't think so. If the pregnant couple read the contract and noticed the fine print regarding the buyout provision, it doesn't matter what they naturally assumed the hotel owner was trying to do. Like, the whole, one of the main points of a contract is to explicitly define the terms of the agreement. If you can just subjectively, randomly, at will, ignore black and white letters written on the paper because you claim it wasn't a meeting of the minds, you're just undermining the entirety of contracts. The entire contract theory is less important now, less efficacious now. I hard disagree with this meeting of the minds concept. Like, if you need to read the contracts, you need to read the entire contracts that you're signing because that's what you're agreeing to, because that's what contracts mean. And if you're trying to find a hotel and somebody gives you a contract that's 73 miles long and maybe 1,000 pages, well, one of two things is going to happen. People are not going to read it. They're going to get screwed, rightfully screwed, or they're not going to book rooms at that hotel because their contract is so long it's absurd. I mean, the market handles this on its own. And the cartel of hotels, again, people just stop going to that area. Word gets out. These hotels are shady. You can't say these people own their property if they're restricted by your magical meeting of the minds spiritualism to contract for their use of their property in whatever way they want. Another way to understand the magnitude of the fraud in measurable terms is to view the refund as a free option insurance policy for the hotel owner. Here is an example of a free option. Suppose that when you prepaid for the room, it was $100 per night. Then, when the day comes, demand is high and rooms are being sold for $1,000 per night. The hotel owner could exercise his right to give you a $101 refund and then sell the room back to you for $1,000. In reality, you never actually had a reservation. On the other hand, if the hotel was empty and rooms were going for $50, you would be held to the $100 price with no refund for canceling. An argument could be made that, on average, the guests benefit from lower room rates to the extent competition drives down prices by subsidizing room leases with the profits from oversubscribing. A similar argument could be made that adding water to milk lowers the price per gallon of milk, and therefore all milk buyers benefit. In a world where people were not allowed to make a legal distinction between milk water and milk, all milk would be watered down. The fact that some guests, quote, save money, is of little comfort to the woman giving birth in a barn. Stated another way, on an average day, most people in a Ponzi scheme make money, but everyone still participating on the last day loses all. The bottom line is that the fine print can still be used to effect fraud by getting people to agree to things they don't understand or for which they have no other choice by virtue of systemic fraud across all market players and or institutionalized by governments. Ignorance is not fraud. Being ignorant is not to be made victim of a fraud. Agreeing to something you don't understand does not make you a victim of fraud. You are not owed hotel service by the universe. If it's these people's rightfully owned property, then they can make whatever dumb rules they want in their contract. I take objection to that entire section. Our financial system. The frauds described above are systemic in our financial institutions, and take many forms including fractional, aka fictional reserve banking, borrowing money payable on demand and lending it for 30 plus years, naked shorting, and futures markets that can be settled in freshly printed cash instead of delivery. Our financial system has made all banks equal through insurance cartels and implicit government bailouts. Henry Ford once said, quote, "It is well enough that people of the nation do not understand our banking and monetary system, for if they did, I believe there would be a revolution before tomorrow morning." End quote. This sounds like something that people should be aware of when negotiating a peace treaty. Gresham's law states that absent choice, quote, "bad money drives out good." Note that Gresham's law only applies when bad money is mandated by law to be equal to good money. I would like to propose a new law, which I believe to be equally true. Quote, "Legalized fraudulent institutions drive out good institutions." All frauds pay higher yields in the short term by masking hidden systemic risks. A bank that is willing to use the same collateral to back multiple debts can lend money cheaper than it otherwise could and pay higher interest to depositors. An honest bank would have to issue a 30-year certificate of deposit to make a 30-year mortgage. When was the last time you saw a 30-year certificate of deposit? When was the last time you even heard of a certificate of deposit? No true democracy can tolerate legalized fraud. That is why the title transfer theory of contract, or smart contracts, should be a fundamental component of any community peace treaty. Good lending principles. When deciding whether to make a loan to an acquaintance, you would be wise to ask them how they intend to pay it back. The things you would look at is their total debt relative to their assets and income. If they have assets they could sell to pay you back, then your loan is more secure than if they have no assets. Traditionally, the ability to work and produce wage income is considered an asset. However, under the principles of smart contracts, this amounts to an unenforceable promise. The value of this asset depends upon their skill and must factor in the cost of living and reputation. It could easily fall to zero. Lastly, you want to ensure that there are no other debts that have a higher priority lien over what you are owed. When deciding to lend to a company, you also need to assess the company's ability to repay. The easiest way to do this is to look at the company's market capitalization. This is normally calculated as the price of the most recent trade multiplied by the total number of shares. This market capitalization overestimates the value of the company because the price per share depends upon the total number of shares being sold. If you had to liquidate 100% of the company instantly, the value would be much less than the market capitalization. Furthermore, the market capitalization would go to zero if there are no buyers. The base value of a company is the value of assets owned by the company, which could be liquidated and distributed to the shareholders. When you deposit money in a bank, you are making a loan. To calculate the market capitalization of a bank, you must consider its assets and liabilities. In this case, the liabilities include the money owed to its depositors. Its assets include any money on hand and the promises of borrowers to repay their mortgage. The value of promises from home buyers depends upon the economy, job market and housing market, as well as upon the weather and natural disasters. For the sake of clarity, I'm assuming gold coins are money. A gold coin can only be in one place at a time. With smart contracts, a deposit loan must be secured by assets. If the deposit is payable on demand, then the bank must have title to a gold coin in its vault. If the bank is going to lend out the gold, then it cannot promise to transfer title to the gold coin on demand because the gold could be lent out and the loan could default. In this case, the deposit contract would be payable in gold plus interest on demand or the collateral pledged by the bank when borrowing your money. The collateral the bank can pledge is its equity. The bank's equity represents shares in all assets owned by the bank, which are not subject to liens under a smart contract. This means the gold backing deposits payable on demand is not an asset of the bank. Since gold payable on demand is not an asset of the bank, we can ignore these depositors and assume a bank starts with no deposits. The bank should only accept your deposit if it wants to borrow your money. It would only want to borrow your money if it could lend the money at a higher rate. This means that the bank can't use the funds from your deposit as collateral for its loan, at least not directly. It would be like a bank lending you money, and instead of backing the loan with a house, it backed the loan with money it lent you. You would be unable to use the money because it had a lien, which makes the loan pointless. To solve this problem, banks borrow money from depositors and back the loans with their equity, shares in the bank. Equity represents a share of the unencumbered assets of a bank. When you loan money to a bank, making a deposit, it becomes an unencumbered asset of the bank. Should depositors expect the same lending standards the bank expects from borrowers? I think so. When a bank lends you money backed by your house, it expects, assuming sound banking, the house to be worth at least 25% more than the loan. This protects the bank from market fluctuations in the value of the house. Following this principle, the value of the equity backing your deposit should probably be worth at least 25% more than your deposit. The consequence of this is that a new bank must bring $25 of its own assets to the table for every $100 of deposits it takes. If we change the language slightly, it becomes obvious. A bank should have $125 worth of collateral for every $100 it wants to borrow. What is good for the goose is good for the gander. When you borrow money to buy a house, the bank expects the loan to be repaid with interest. It is rare for a bank to lend someone money for an unlimited term and then ask for no payments. The closest example is a reverse mortgage, where the loan balance grows over time. The key to reverse mortgages is that the collateral starts out as being much higher value and gradually approaches 80% of the loan value. The idea of a reverse mortgage is that the loan is paid off when the house is sold. When lending money to a bank, a depositor should have similar expectations of payment. There are several ways a bank could pay off a loan to a depositor. 1. Return deposits that haven't been relent. 2. Borrow money from a new depositor. 3. Use income streams. 4. Sell equity held as collateral. When a depositor requests their money back from the bank, it is like the bank requesting immediate repayment of some or all of a mortgage. If a home owner is unable to produce the cash on demand, then the bank can seize title to the house. Likewise, if the bank is unable to produce cash on withdrawal because the depositor should be entitled to seize the equity, upon seizing the equity, the depositor can either sell the equity, likely at a loss, or hold the equity and collect dividends while waiting for capital gains. In any case, where the bank was unable to give the depositor cash on demand, the depositor will likely have their liquidity impaired by the average duration of loans made by the bank. If they want their money immediately, they will only get the net present value of the loan book. In any event, the risk of depositing money in a bank is derived from the surplus assets owned by the bank and the quality of the loans the bank makes. A bank that makes loans with quality collateral to people with good cash flow for short durations will be safer than a bank that makes loans with low quality collateral to people with poor cash flow for long durations. The bank would have to offer interest rates commensurate to the risk embedded in the bank's balance sheet in order to attract capital. All of this is compatible with smart contracts, and all loans, mortgages, and deposits are free from risk of bankruptcy, and bank bailouts are never required. That said, there is still a high degree of moral hazard associated with allowing someone else to re-lend the money you lent them. This moral hazard is further amplified if the decision-maker at the bank is an employee and not an owner, because the owner has some of his own money on the line, whereas an employee has nothing but their job at risk. They could be making money whether or not you lose everything. If you are going to lend your money to a bank and then give the bank discretion over who to lend to, then it would be wise to ensure the bank's incentives are aligned with yours. Ideally, the bank owner and managers would not be allowed to take any money off the table in the form of dividends, salary, or operational overhead until the loans they make are paid back with interest and losses from failed loans are offset. If the bank owners or managers take money off the table before all the risks they have taken are realized, then they can make decisions that generate short-term returns with long-term tail risks. A tail risk is something that blows up at the end, quote, blows up at the end, such as loans with balloon payments, variable interest rates, a housing market bubble blowing up, etc. Giving banks unlimited discretion over how to utilize bank assets also creates moral hazard and jeopardizes depositors' lenders' funds. Suppose a bank was allowed to do more than lend. Suppose it could buy real estate and stocks with depositor funds. They could extract value from the bank by overpaying for real estate and other assets purchased from a friend. The bank would also be buying volatile assets with 4 times the leverage. When a bank makes money by lending, its interests are aligned with depositors to get a return on their money without risking principal. When a bank makes money by capital gains and leverage, its interests are now divided because it could profit on the side by front-running the bank's purchases. The risk profile of lending to a margin trader and lending to a lender are vastly different. In a free market with ample competition, there is room for all kinds of banks, utilizing different asset management policies. When a bank lends you money, they ask for proof of income and a home inspection. The bank knows exactly what is collateralizing their loan. When you lend money to a bank, you should demand the same level of transparency about the assets backing the bank's equity. Often companies can issue new shares at any time with the approval of the shareholders. Rational shareholders only approve of such issuance if it increases the value of existing shares. When a bank uses its shares as collateral for borrowing money from depositors, the depositors now have an interest in the value of the shares. The bank should not issue new shares without depositor approval any more than you should be allowed to sell some or all of your house without paying off the loan or permission from the bank. If you borrow money from the bank secured by 100% of your house, then you cannot borrow money from another bank secured by the same 100% of your house. Likewise, if you deposit money into a bank, the bank would not secure it with 100% of its equity. Doing so would prevent it from borrowing money from other depositors. The shares collateralizing your deposits should be allocated at the time of the deposit. Otherwise, each new deposit accepted by the bank compromises the collateral of existing depositors. If the bank loses money, then new depositors would get more equity, shares, collateralizing their deposits than the original depositors. If a bank makes money, then the new depositors would get less equity, shares, collateralizing their deposits. Instead of a bank failing all at once, only the least collateralized depositors would be converted to equity. A bank has an interest in ensuring that your debt-to-equity ratio stays below 80%. Many loans have terms that allow the bank to call the loan and seize the collateral if the house price falls too much. The borrower can either pay off part of the loan to restore the debt-to-equity ratio, or pay off the whole loan by giving the bank the title. If depositors loaned the bank money under the same terms, then any time the bank took a loss, all depositors would demand more equity to be added to the deposit collateral. Based upon this analysis, the vast majority, maybe all, of too-big-to-fail banks operate in a state of bankruptcy. Their equity is worth less than their debt. They are able to keep operating because the Federal Reserve is willing to lend banks money using collateral valued at non-market rates. Furthermore, the rules allow the banks to pretend that their assets are valued at other than market prices, voluntary trade, e.g. an auction. Even their equity values price in the support of the Federal Reserve and bailouts, and therefore the shares are valued higher than the assets alone. The banks operate only by ongoing legalized deception and fraud. The bigger the fraud, the harder the ultimate fall. If individual banks had to issue their own banknotes, then each bank would discover the market would discount their notes based upon individual reputations. Consider that closer. Do you prefer to get dollars from a bank? Consider that closer. Do you prefer to get dollars from Bank A because their reputation and history is far better than Bank B? Or do you consider that all banks equal? The Federal Reserve System violates the principle of treating assets of different risks to be equal by treating non-fungible bank deposits as fungible. Is a dollar no matter who owes it to you? Consider how different that would be if the FDIC and the Federal Reserve didn't exist. Further, consider that the FDIC is also a fraudulent promise because it lacks the assets to back its guarantees to all its depositors. Considering the debt of Bank A equal to the debt of Bank B is like the hotel considering rooms that sometimes flood equal to rooms that never flood. Gresham's law takes over and drives the good bank out of business, or reduces the quality of the good bank to be equal to the quality of the bad bank. A bank run could expose the fraud in a single bank, leaving the majority of the economy to carry on. The banker should then go to jail for fraud. When governments create laws that make all bank debts equal and prevent their redemption for the asset that was originally deposited, bank runs are no longer possible. Everyone views all banks as the same because the government, via their regulated banks, can always print more money to bail them out. Under this system, you are guaranteed to get your, quote, cash back, but you are not guaranteed that cash will have the same purchasing power in the market. In effect, money becomes nothing more than, quote, equity in the banking system, and printing money is nothing more than, quote, raising capital. The money will have value so long as existing shareholders are willing to tolerate the loss of the purchasing power of their savings. Unlike companies issuing new shares, dollar holders lack voting rights on the issuance of new money. There is nothing that ensures that new money is only issued if it raises the value of all money, or increases the collateral backing, the money. The power to print money combined with contracts that allow failure to deliver commodities to be settled in cash gives the banks and government complete control over all prices. They can sell more commodities than are theoretically possible to exist, suppressing the price. And anyone who attempts to take delivery, e.g., use their hotel room, calling their bluff, will be paid in cash, which they can create from nothing. This is like the hotel owner selling more room reservations than they have, and when someone shows up to actually sleep in the room, they simply offer them a cash refund. With this control comes unprecedented power for insiders to buy low and sell high, because those running the system are in control of price movements. While there is nothing morally wrong with raising capital by selling shares, doing so normally requires approval of the shareholders. Would you invest in a company that gave the CEO the power to issue shares unilaterally, as well as the power to control how the funds were spent? e.g. bonuses for himself and low-interest loans and bailouts for friends? If not, then why do you invest in holding dollar and dollar-denominated debt? Cryptocurrency exchanges. Bitcoin was created to address the systemic fraud in our financial system. It achieves this through radical transparency. All market participants can verify the total supply of coins, and no one is able to create fraudulent Bitcoin. It is like installing a live feed in every hotel room so that you can verify no one is sleeping in the bed you reserved, and having thousands of people constantly checking the feed for you. Also, the reservation book is public, so everyone can see who has reserved a room, and that no rooms are double booked. Unfortunately, Bitcoin held on exchanges is not, quote, Bitcoin, any more than bank deposits are gold. Instead, quote, Bitcoin held on exchanges is a debt of the exchange which is collateralized by the value of the equity of the exchange. An exchange operating with integrity has one real Bitcoin for every Bitcoin it owes its customers. Furthermore, such an exchange should hold customer funds in segregated accounts so they cannot be used to pay the debts of the exchange. Many exchanges offer margin trading, where they will lend customers Bitcoin and other assets backed by collateral. In the event the collateral falls in the value of the exchange, the exchange will liquidate the collateral and cover the debt. In this case, the equity of the exchange is no longer backed by Bitcoin held in segregated accounts, but by the collateralized promise to pay Bitcoin. This arrangement is similar to banks replacing, quote, gold notes backed by gold with gold IOUs backed by bank equity, which owns the mortgages which promise to pay gold. Regardless of how well collateralized the loan is, if a bank or exchange cannot liquidate the collateral fast enough, it could end up owing more than the assets it possesses. Since margin traders want control over the timing of converting their loan, the exchange must lend the money for a minimum period of time, days or months. To make these margin loans, the exchange must have title for an equal period of time, days or months. To avoid, quote, borrowing short and lending long, an exchange with financial integrity would have to borrow money from depositors on matching terms, e.g. a certificate of deposit. An exchange that promises depositors they can withdraw on demand and promises margin traders they have a minimum period they can maintain the loan, assuming collateral is still good, is committing financial fraud, even if the regulators permit it. What we can conclude is that cryptocurrency exchanges should be following the principles of sound banking and the title transfer theory of contract. This includes distinguishing between, quote, gold notes backed by gold and, quote, gold IOUs backed by exchange equity, which is backed by, quote, mortgages, e.g. collateralized margin positions. The principle of, quote, no bankruptcy indicates that in the event the exchange's equity value is less than its assets, that the equity holders should be automatically wiped out and the debtors receive their pro rata share of all equity. The owners of an exchange are resistant to such terms for the same reason nobody likes the repo man towing their car for failure to pay. Instead, exchange and bank owners want to pretend they are not insolvent and will somehow earn their way out even though the market doesn't believe it is possible based on share price. Lending money to an exchange or bank on lesser terms is no different than lending $100 to a bum on the street and hoping his gambling addiction will pay off. The masses generally don't know what financial integrity entails, nor what to demand from an institution. As a result, they will accept terms and conditions that effectively grant an unsecured loan to sophisticated gamblers engaged in, quote, socially acceptable financial fraud with a, quote, low probability of getting caught on any given day, but a guarantee of getting caught eventually, hopefully after those perpetrating the fraud are dead. Risks can be transferred but not destroyed. All financial fraud is a calculated risk of getting caught versus profit from the fraud. Someone is profiting by keeping profits and transferring risks. It is the owners of the financial institutions that profit from the fraud and the depositors, which take the uncompensated risks. As financial institutions are nationalized through regulation, it is the bankers who profit, and the population as a whole which takes the risks. Since risks are never destroyed, the depositors and population are guaranteed to lose. An uncompensated or undercompensated transfer of risk is someone getting something for nothing while someone else is getting nothing for something. The principles of financial integrity cannot tolerate such free lunch arrangements. Stated another way, you could have a successful transaction with another party and still be defrauded. Generally, people don't consider, quote, unrealized risks to be fraud. The idea that the very structure of a contract could be fraudulent is a foreign concept. The title transfer theory of contract makes it very clear that any contract that transfers title to assets you don't own is fraudulent. Yeah, but earlier he said property rights exist in the time dimension too. So, yeah, that seems contradictory. But, I mean, okay, if you want to agree with somebody to only make contracts, to only enforce contracts between you that are based on this specific limited time transfer or title transfer theory of contract, I mean, you're free to do so. The masses are attracted to a Ponzi scheme because of the returns are high and they expect that they can exit the Ponzi before it collapses. The risk of a Ponzi collapsing tomorrow is near zero, but the risk of it collapsing someday is guaranteed. How does one escape a Ponzi economy before it collapses? It cannot be done, and everyone loses. This is why it is imperative that everyone understands financial integrity and then demands it from their institutions and community peace treaty. It is every individual's responsibility to conduct their affairs with financial integrity and avoid doing business with those supporting systemic fraud. Delegated power and community debt. Now that we have an understanding that you cannot borrow short-term and lend long-term, we can apply this principle to borrowed power. When we use political playoffs to elect people to positions of power, they are only lent that power for a limited time. You know what? I'm actually going to put a bookmark in it here, and I think next time we'll definitely be finishing the book. Yeah, there's only about 25 pages left. All right, guys. I hope you're enjoying these Let's Reads. I'm already planning the next book in the series. If you have any suggestions for books that you'd like to see me read and comment on, just let me know. All right, guys. Have a great day.